February 15th to order. Senator Dietrich, do you have some guests with us today?
I do. Thank you, Mr. Chairman. I have 4 pages with me from Indian Hills Elementary and USD 437. I have Braxton. Wave your hand, Braxton. John, Akul, and Will. So they'll be with me today, and they're looking forward to that dome tour and a very riveting discussion in FI&I.
Welcome to committee, young men. Senator Warren, do you have a point of personal privilege?
Yes, Mr. Chair, thank you. I don't have any pages with me today, though they're welcome to come up. Wanted to clarify about the committee documents that we were talking about yesterday and testimony. And after committee yesterday, I asked my office assistant to put the testimony from prior hearings in the proper bill order, and so they had been provided. I just want to clarify that they had been provided, and also finding documents on the website for those following along online, how you access those. It's a little bit different for each committee, which was why I was having trouble navigating that yesterday, but they were there online, and so I just wanted to clarify that for anyone following along and who wants to look up. To find these committee documents, I think you go, you can go to the bill and look up which day the bill was heard, and then you go to the calendar for this committee for that day, and you click on the day, and then you can click on committee testimony, if I have that right. So hopefully that helps the public navigate this a little easier as well. Thank you, Mr. Chair.
Thank you, Senator Warren. Okay, we will now turn our attention to a hearing on Senate Bill 27. We'll open that hearing. Eileen, you want to give us a bill brief?
Thank you, Mr. Chair and members of the committee. Senate Bill 27 amends KSA 40-4905, 40-4906, and 40-5505 relating to fees charged by the Insurance Department. The bill would give the Commissioner of Insurance the ability to set the amount of these fees charged with an upper limit provided in statute. So under current law, KSA 40-4905 requires that a person applying for a resident insurance agent license pay a non-refundable fee of $30. Senate Bill 27 would amend that provision to state that a person applying for a resident agent license would be required to pay a non-refundable fee in an amount not to exceed $30. The bill would also require that the commissioner set the amount of the resident agent license fee for the following year and publish it in the Kansas Register by December 1st of the year. Similarly, under current law, KSA 40-4906 requires that a non-resident person who is applying for a non-resident agent license pay a non-refundable fee of $50. Senate Bill 27 would amend that provision to state that the non-resident person would be required to pay such a fee in an amount not to exceed $50. And again, as with the previous statute, the commissioner is required to set the amount of the fee for the following year by December 1st of the year and publish it in the Kansas Register. Last but not least, under current law, KSA requires that an applicant for a public adjuster license pay an application fee of $100. Senate Bill 27 would amend that provision to state that an applicant for a public adjuster license would be required to pay a fee in an amount not to exceed $100. And again, as before, the commissioner is required to set that amount for the application fee for the following year by December 1st of the year and publish it in the Kansas Register. If enacted, the bill would go into effect on July 1st of 2023, and I can stand for questions.
Eileen, thank you very much. Committee, are there questions? I see none. We will now turn our attention to the proponents. We have Eric Turek with the Kansas Insurance Department. Welcome, Eric.
Thank you, Mr. Chairman, members of the committee. Eric Turek here from the Kansas Insurance Department. Very happy to talk to you today about Senate Bill 27. And Eileen described the contents perfectly. Essentially in statute, and this is one of the bills that this is a crown jewel of ours on the department's legislative agenda. It's a way for us to truly right-size our operations, reduce fees, and to ultimately save the industry money. So in statute, there are statutorily set fees of $30 to be licensed if you are an insurance agent. If you're a non-resident and you want to receive licensure, that would be, it's $80 during the initial licensure, and then, or that's the initial fee, and then $50 every 2 years after that. And for public adjusters, whether you are a Kansan or an out-of-stater, it's $100. All this bill does is allow the flexibility to lower those fees set by and to have the commissioner set those. So it's a very, very simple bill. We're happy to save money wherever we can for the industry. Happy to answer questions.
Eric, thank you very much. Committee, are there questions? Senator Gossage.
I noticed that in the last paragraph, or under the note from the reviser, that it mentions the license for public adjuster. But would this be licensed for all, for anyone getting an insurance license in the state?
So this only applies to insurance agents' licenses and public adjuster licenses, whether you're a Kansan or you're not.
So a resident license would be the same as a non-resident license, or the non-resident is the 50 and the resident is 30?
Sure, so I'll clarify. So when I was describing that discrepancy between the resident and non-resident, that was just for insurance agents. For public adjusters, whether you are a resident or non-resident, or seeking to apply for a resident license or non-resident license, it's statutorily set at $100 regardless, so.
The public adjuster only?
Yep.
So what is it currently for an agent?
Yeah, for an agent, resident, non-resident, all the above. For a resident agent, it's $30 is the initial fee that we're speaking to here. For non-resident agents, it's $80 the initial fee, and then it's a $50 biennial fee.
Okay, so what would be, you're saying we're setting a cap, what would be the cap?
So already in statute, there is this fee. This would allow the commissioner to lower every one of those fees upon determination.
Okay. The reason I'm saying this is, some of you know, I'm licensed in nearly half the states, and we're the lowest one. I have to pay $100 for some states, $200 for others, and Kansas is like, wow. And I have other agents who are like, well, one of the first states I got licensed in was Kansas because their rates are lower. So this is not at all too high. Thank you so much.
Committee, are there additional questions? I see none. Thank you, Eric. Is there anyone else that would like to testify as a proponent on Senate Bill 27? Are there any neutrals? Any opponents? Seeing none, we'll close the hearing on Senate Bill 27. We will now look at Senate Bill 28, open the hearing, and ask Eileen for a bill brief.
Thank you, Mr. Chair and members of the committee. Senate Bill 28 creates a new provision of law, amends KSA 44-588, and repeals KSA 12-2623 and 44-587, all for the purpose of eliminating assessments paid by group-funded insurance pools and group-funded worker compensation pools to the state for supervisory services and refunding current balances in the pool's associated fee funds and winding down those funds. Currently, under KSA 12-2623, shortly after January 1st of the year, the insurance commissioner estimates the expenses for state supervision of the group-funded insurance pools for the fiscal year beginning on July 1st. Then, not later than June 1st of the year, the commissioner notifies each of the participants in the group-funded pools of the amount of each assessment, which then becomes due on July 1st of the year. The monies are paid into the group-funded pools fee fund. The identical process for group-funded worker compensation fee funds occurs under 44-587. Senate Bill 28 would end the assessment process and refund all monies in the fee fund. The bill creates the group-funded pools refund fund, or refund fund, on July 1st of 2023 and directs the Director of Accounts and Reports to transfer the balances and existing liabilities of the group-funded pools fee fund and the group-funded workers' compensation fee fund into the refund fund. It got laughs in the House, too, so don't worry. The remainder of the monies left in the refund fund would then be returned to the entities that paid into the fee funds on a prorated basis based upon the premium taxes paid by each entity in the 2022 fiscal year. The bill would then abolish the group-funded pools fee fund and the group-funded workers' compensation fee fund, and the refund fund would be abolished on July 1st of 2024. Lastly, Section 2 of the bill strikes a portion of KSA 44-588 that refers to fees paid pursuant to 44-587, which is one of the fees that's being abolished. And if enacted, the bill would become effective on July 1st of 2023. I can stand for questions.
Thank you, Eileen. Committee, are there any questions of Eileen other than asking her to say refund fund 10 times as fast as she can?
I know how many chucks a woodchuck can chuck, too.
I see no questions. We will now turn to the proponents. We have Eric Turek once again with the Kansas Insurance Department.
Thanks again, Mr. Chairman. Eric Turek here with the Kansas Insurance Department. Senate Bill 28, another item on the department's legislative agenda. We are in support of this bill. Essentially, there are assessments that the insurance department has the ability to, assessments, really that's another term for fees. Pertinent to the bill concerns group-funded pools, group-funded workers' compensation pools, and a specific assessment in statute that allows the commissioner to impose a fee to cover the cost of supervision and administration per KSA, the two statutes that are being repealed in this bill. Those statutes both state the Commissioner of Insurance shall estimate the expenses necessary for the administration of the group-funded workers' compensation pools. The other statute 2623 says the same thing about the group-funded pools. So the bill would repeal that language. Essentially, these assessments since 2015, the department has not assessed the pools for this specific assessment, so this fee has not been imposed on the pools. And so these funds actually haven't grown. They've just been sitting there idle, about $153,000. And so essentially this bill repeals those funds and just returns those to the pools on a prorated basis. So roughly $153,000, $40,000 to those who paid into the group funded pools fee fund of, that's like $40,000. I think my testimony actually says that. And then $112,000 to the employers who paid into the group-funded workers' compensation pools fee fund. So we're happy to return money where we can, and happy to answer questions.
Eric, thank you very much. Committee, are there questions? Senator Pittman and then Senator Fagg.
Thank you. Thank you, Mr. Chair. Thank you, Eric. Mr. Turek, when we talk about abolishing workers' compensation funds, obviously it gets a little, people get nervous. We want to be very, very clear. This is a fund that is used to pay the fees for the assessment. Is that correct?
So I do want to be clear. This bill only pertains to pools. So this does not pertain to group-funded or workers' compensation in general. There are assessments that the department makes upon employers to fund the second injury fund. This is not talking about that at all. This is a separate fee fund just for the pools. So I'm not talking about general workers' compensation in general.
These group-funded workers' compensation funds, what would they normally be used for, so we can be clear?
So, sure. So essentially financial examinations. We receive, so those are discretionary. The department has not found the need to examine these pools since 2015. That's why the assessment really hasn't taken place. We receive the quarterly reports and financial statements from pools. We just really haven't seen a need to assess them or examine them. I will say too that when we do examine entities, we also bill them for the examination. So really, these funds are just sitting there. I can't speak to the impetus as to why this was enacted in the first place. It was under this several previous administrations ago. We don't find the need to impose this specific fee.
Just for all my folks back home, this is about abolishing a fund that's it's paid for by fees. It's a rainy day in case there needs to be a financial assessment on these things. And then that goes away because we've not needed it for years, and that money just gets returned to those funds. And if you actually had to do a financial assessment that would normally have come out of these funds, it would just be billed to those particular funds.
And we're already covering the cost of that fee. Again, I can't speak to why this fee was necessary in the first place. We don't find it necessary.
Thank you.
Senator Fagg.
Thank you, Mr. Chairman. Eric, thank you for your presentation. I think you answered my question, but I want to make sure, when is the last time we've had activity in this account?
Since at least 2015, when our records show, yeah.
Okay, thank you.
Committee or Senator Dietrich.
Thank you, Mr. Chair. And you may not know the answer to this, but so if you return the money to those pools, what are they going to do with it? Is it up to them?
So there are 3 group-funded pools that involve municipalities, and there are 14 group-funded workers' compensation pools that involve employers, $40,000 for the municipal groups, and $112 for the employers. What they do with it, that's up to them. Yeah.
Eric, my guess would be that it would be put into reserves within that pool funded, and then at such time, if they wish to make it part of a dividend to their members, which would then have to be approved by the commissioner before that dividend could be distributed, but that's probably most likely where it would go.
And the bill doesn't speak to that, so.
Are there additional questions? Eric, I see none. Thank you. Are there any additional proponents on Senate Bill 28? Any neutrals? Any opponents? Seeing none, we will close the hearing on Senate Bill 28. We will now open the hearing on Senate Bill 62. Eileen, would you give us a brief?
Every time I speak after Eric, I realize just how tall he is. Thank you, Mr. Chair. Senate Bill 62 would enact the Protect Vulnerable Adults from Financial Exploitation Act, which provides a framework within which a qualified individual may report actual, attempted, or suspected financial exploitation of a vulnerable adult and provide for immunity from civil and administrative liability for making such report. So Section 1 of the bill provides the citation for the act. Section 2 provides definitions for the act. Section 3 of the bill provides the conditions under which a qualified individual may report actual, attempted, or suspected exploitation of a vulnerable adult to the Securities Commissioner. Section 4 provides for immunity from civil and administrative liability when the qualified adult makes such a report under Section 3 in good faith and exercising reasonable care. Section 5 of the bill provides that were a qualified adult to reasonably believe that exploitation may have occurred, been attempted, or is being attempted, the qualified adult may notify a third party designated by the eligible adult unless the third party is the individual suspected of committing the exploitation. Section 6 provides for immunity from civil and administrative liability when the qualified adult makes such a report under Section 5 in good faith and utilizing reasonable care. Section 7 provides for conditions under which a broker-dealer or an investment advisor may delay a disbursement from the account of an eligible adult or an account on which the eligible adult is a beneficiary. Section 8 provides for immunity from civil and administrative liability when a broker-dealer or investment advisor delays such a disbursement under Section 7, again, in good faith and exercising reasonable care. Section 9 of the bill provides for access to records that are relevant during an investigation undertaken by the Securities Commissioner or law enforcement, and the section also makes such records confidential and an exemption from the Kansas Open Records Act. Section 10 provides for disciplinary actions that the Securities Commissioner may take if warranted. The bill would take effect on July 1st of 2023 if enacted, and I can stand for questions.
Thank you, Eileen. Committee, are there questions? Senator Dietrich?
I know what I would consider a vulnerable adult, but there's no definition that I can find in here. Is there? Did I miss it? And it goes from vulnerable adult then to eligible adult.
Eligible adult and vulnerable adult are going to mean the same thing.
I just thought maybe vulnerable could stand a definition. Oh, okay. Eric said he'll speak to it, so thank you. Thank you, Eileen.
Senator Warren.
Thank you, Mr. Chair, and I have the same question as Senator Dietrich, so it'd be good to have that further defined. I do see that financial exploitation is defined as in KSA 39-1430. Are you able to provide any examples of what financial exploitation would be and what it would mean under this act?
I could pull the statute up and provide it for you, but I don't have those notes in front of me right now.
I'm pulling up the statute myself. I may have further questions later for proponents. Thank you, Mr. Chair.
Okay. Thank you very much. Committee, are there additional questions of Eileen? Senator Pittman.
Thank you, Mr. Chair, and thank you, Eileen, for the excellent overview there. It says that they may delay the disbursement from the accounts when they find this, and they can do so without necessarily notifying those folks. But it looks like there's an expiry date on that, like 25 days or something like that, 15 or 25 days, that on page 3 at the top, that they have to, that there seems to be, there's a limit in terms of how much they can. Is that correct, or am I misreading that?
So under subsection B of section 7, it says that any delay of a disbursement authorized shall expire on the soonest of, first, a determination that the disbursement's not going to result in financial exploitation, or 2, 15 business days following the date on which the broker-dealer or investment advisor first delayed the disbursement. And that just gives the broker-dealer or investment advisor time to figure out what exactly is going on or not.
Okay, thank you.
Any additional questions of Eileen? I see none. Thank you.
I'm sorry, Mr. Chair, let me just add, further in paragraph 2 of that, if the commissioner does request, that 15-day notice can expand to 25 days.
Thank you. All right, we will now turn to our proponents. Once again, we have Eric Turek with the Insurance Commissioner's Office.
Thank you, Mr. Chairman. Eric Turek here from the Kansas Insurance Department. Senate Bill 62 is a key item also on the department's legislative agenda. It's the only item that primarily pertains to our securities division. I do want to note that in the audience behind me, we do have Dan Klukas, the Kansas Securities Commissioner, and our Assistant General Counsel, Clay Johnson. So they're also there to answer any questions, but to Senator Dietrich and Warren, I can definitely answer those questions you had. Senate Bill 62, this mirrors the North American Securities Administrators Association, or NASA, their model law to protect vulnerable adults from financial exploitation. And Eileen did describe the contents of the bill. Essentially, this would require securities registrants or investment advisors and broker-dealers to report to the Securities Commissioner any suspected financial exploitation of a vulnerable adult, and I will get into that definition in a little bit. In addition, these registrants, they do have the option to, this is a may, not shall option, to delay the disbursement of funds if in good faith and if reasonably they believe that a disbursement of those funds may further financial exploitation. And then in addition, as Eileen stated, there's a cap on that to 15 business days. If the commissioner may find a reason to delay or to further delay that disbursement, you know, when the Office of the Commissioner does receive a report, there may be a reason why we may want to further investigate. Is the person who is an account holder choosing to invest in someone who's not a securities registrant? There's definitely there's definitely a reason why we would want to look into that. I do want to mention that in current law, a whole host of professions already have to report financial exploitation to DCF for certain adults, but they also have to report suspected neglect and abuse. This bill only has to deal with just with the financial exploitation, and it would just be to the the Securities Commissioner. Some of those professions that have to report to DCF are like medical professionals, psychologists, counselors, therapists, firefighters, attorneys, law enforcement. In statute right now, securities registrants don't have to report anything. We would hope they would tell us if there was some suspicious activity going on, but there's nothing in law right now that encourages them to do so. We believe that this is the most effective way for registrants to report such behavior, while also not exposing them to criminal liability for making those reports. That's why there's those two sections on immunity from civil and administrative liability. And I'll just say this too, those civil and administrative liabilities, we find that in a lot of other states. 34 other states have enacted this model law, including our adjacent states. To some, I'll really just say that financial exploitation can happen pretty quickly. It's just a matter of a flick of a wire transfer. This bill will ultimately lead to the better protection of Kansans. We also think this is a win-win for everybody, in our opinion. I'm happy to stand for questions, and I know so is the commissioner. So happy to stand for questions.
Thank you, committee. Senator Dietrich.
Definition,
Yeah, a vulnerable adult, you stated.
an adult with disabilities?
Yeah, so that's, sorry, I've got a whole bunch of statutes here, so forgive me.
I think in your testimony, you
yeah.
say,
A dependent or vulnerable or elderly adult in my testimony, I think I state. I'm going to get you that number here in a second.
Eileen has a definition for you.
thank you.
Eileen, go ahead.
Thank you, Mr. Chair.
I've got it. Eileen, if you want me to.
No, I'm trying to find it on my screen again. I switched screens. But if you, go ahead if you've got it.
Sure. Section E of the bill, or line 22, it refers to eligible adult per KSA 215417. So this would mean a dependent adult, an individual 18 years or older who is unable to protect the individual's own interest. Also, an elder person would mean 60 years or older. So, Eileen, I don't know if you have anything else to add to that.
Yes, Mr. Chair. It's defined in the statute as a dependent adult, and then examples are a resident of an adult care home, including but not limited to, certain adult care facilities, an adult being cared for in a private residence, an individual kept, cared for, treated, boarded, confined, or otherwise accommodated in a medical care facility, individuals with intellectual disabilities or developmental disabilities receiving care through a community facility for people with intellectual disabilities or residential facilities, and individuals kept, cared for, boarded, confined, or otherwise accommodated in a state psychiatric hospital or state institution for people with intellectual disabilities.
Senator Dietrich.
Thank you so much, Mr. Chairman, and Eileen, thank you. So I would just ask that if we work this bill, that we include a definition somewhere, either cite it. Were you reading off of a statutorily?
It is.
Yeah. Mm-hmm. Where is it cited in the bill? That's what I'm looking for. I'm missing it. Got it. Thank you. Thank you very much. Thank you.
Senator Fagg.
Thank you, Mr. Chairman. Eric, thank you for your presentation. I was wondering if you could, how many complaints in your office in 2022 on issues addressed in Senate Bill 62?
Sure. I can definitely defer to our Securities Commissioner. What I can say is that during a downturn, we do see an increase in securities fraud and financial exploitation. In addition, when we have a larger group of vulnerable adults as it pertains to this bill who are saving, who are investing. I know that during calendar year 2022, there was about $1 million returned via restitution. Did you have anything else to add?
Good morning, Mr. Chair and committee. Dan Klukas, Securities Commissioner. These are cases we regularly work on, Senator Fagg. We haven't at this time kept numbers of exactly how many. I can tell you that currently we have about 3 of these in investigation. And as Eric said, once this money leaves these folks' account, it's gone. We can try to seek restitution. Restitution isn't as good as we hope. But yeah, we do handle these. It's not our biggest number, but sometimes it's the it's the ones that make the biggest difference in these families, because if it's a life savings that's gone at that point with no time to recover.
Senator Warren?
Thank you, Mr. Chair, and thank you for the additional discussion about eligible adult. I'm looking at the statute defining eligible adult, and really it's anyone 18 years of age or older. The examples given in the statute are examples, but it's not limited to only those situations. I guess it's dependent adult means an individual 18 years of age or older who's unable to protect the individual's own interest. Do we have any definition in case law or statute about unable to protect the individual's own interest? I mean, I've got college-age kids, and then they would be subject to this in, you know, governing their own finances, I guess. And while
You know, I think that brighter minds may be able to answer that question a little bit more than I can. But what I will say is, you know, so when it comes to the registrant, if there's something suspicious, they would just report that to us. But the delay of disbursement, if the registrant believes that that disbursement of the funds may further financial exploitation, they may delay. And so this isn't an all-encompassing in every single situation kind of topic, but Eileen may be able to opine a little bit more there.
And I do appreciate the purpose of the bill is protecting our elder community from improper exploitation. And again, because it has such broad application, want to make sure that we're kind of balancing the need there, because you are giving a lot of authority to an investment advisor over your, I don't know, your money market investments and things. And have we had situations where an investment advisor might think, well, that's not particularly a good stock choice, so maybe you don't want to do that, and they might delay a disbursement. Just trying to strike a balance, and would want to know how that's been working in other states as well.
Mr. Chairman, if you wouldn't mind, I'd like to call on our Assistant General Counsel, Clay Johnson.
Good morning.
One thing that may help is that the definition of eligible adult was incorporated by reference from the statute that makes exploitation of vulnerable adults a crime. So care was taken, that statute's been in operation and in effect for a long time in Kansas. So care was taken to kind of make this jigsaw puzzle piece fit with other statutes. So the way that the criminal law has operated with respect to vulnerable adults who are either over 18 and can't protect their own interests, or over 60 would be the source of that law.
Thank you. I would like a further definition of, you know, folks in their 30s and 40s who would be found to be unable to protect the individual's own interest, which they would fall then under this act. So and it could be a follow-up.
Provide the committee with some further clarification. As I understand the bill, the maximum delay, if there is suspicion, is 25 days. Is that correct?
And that's only after, it's 15 days, and it can only be 25 if the commissioner requests. We have to make the request. And again, that's a may, and that would only be if there was information that warranted that further delay.
Committee, are there additional questions of Eric? See none, thank you. We also have proponent testimony from Maxine Goucher with AARP via WebEx.
Good morning, Chairman Longbine and members of the Senate Committee on Financial Institutions and Insurance. My name is Maxine Goucher, and I'm on the Executive Council of AARP Kansas. And thank you for allowing us to come in and supply this testimony in support of SB 62. AARP has more than 278,000 members in Kansas. We're a nonprofit, nonpartisan organization that works across Kansas to strengthen our communities and advocate for issues that matter most to families, such as healthcare, unemployment, income security, retirement planning, affordable utilities, and protection from financial abuse. AARP has a long history of fighting for protection against financial exploitation of seniors and has been on the forefront of advocacy in support of federal and state laws and regulations that prevent this type of abuse. Elder abuse, like many other forms of domestic abuse, is an often hidden phenomenon that affects hundreds of thousands of older Americans. Older Americans are disproportionately affected by financial fraud. Although older people make up just 12% of the population, they contribute a full 30% of the victims of consumer fraud crime. Women, who make up an increasingly larger percentage of the older population by virtue of living longer life expectancy, are the majority of the victims. Financial abuse of seniors can cause injuries far beyond the pocketbook. This abuse frequently affects seniors' physical and emotional health. The state, in many instances, finds itself trying to pick up pieces. Yet efforts to prevent this abuse through the passage of stricter laws is often cost neutral to the state. The enactment of stronger safeguards against the abuse of elders is a win-win situation for states, older adults, and their families. According to the National Conference of State Legislators, elder financial exploitation legislation grew by more than 89% over a 3-year period from 2014 to 2018. From 89 bills in 2014 to more than 168 bills in 2018. In 41 states, the District of Columbia, the U.S. Virgin Islands, lawmakers have enacted tougher criminal penalties to combat financial exploitation of older people and other vulnerable adults. AARP supports strong legal protections against financial exploitation and abuse. Therefore, we ask for your support of this bill. Respectfully, Maxine Goucher, and thank you for letting us testify in support.
Maxine, thank you for your testimony. Committee, are there questions of Maxine? Senator Warren?
Thank you, Mr. Chair. Not necessarily a question for Maxine, but maybe for the reviser, if that's all right. Regarding new Section 8 on page 3, regarding if there's a broker-dealer or an investment advisor who, for instance, was wrong about the financial exploitation and nonetheless withheld the disbursement of funds for 2 days, or I think it's up to 25 days, wouldn't be subject to any civil liability for the wrong decision. Do I have that right? I mean, if you hold up a payment or a disbursement for 2 days, for 25 days, I mean, that could affect your mortgage payment that month, your car payment, all kinds of issues. So am I correct that there wouldn't be anything that the person who had their money, I guess, wrongly withheld, they wouldn't be able to take any action against their investment advisor, I guess, except firing them and moving their account somewhere else?
Eileen?
Thank you, Mr. Chair. The administrative and civil immunity is when the broker-dealer or investment advisor delays the disbursement and using good faith and reasonable care. So it's not going to be something where it's just done willy-nilly and, you know, the individual is granted immunity. And they have to be making a decision in the belief in delaying that disbursement that there is financial exploitation that is occurring.
Thank you. And even though, well, I honestly thought it was exploitation, but I was wrong, that would be protected from any civil liability is what the bill says. So maybe if we could have an example from the proponent of how an investment advisor would look at a situation and determine that there's financial exploitation going on.
Commissioner, or Eric? Commissioner? Thank
Am I
you.
on now? Okay, sorry about that.
No problem.
Thank you for the question. What we've had in the past is when people are moving money for other investments that just don't sound right to the investment advisor representative. So those are the types that we're looking for. We haven't had any, and these are investment advisor representatives that have come to us after the fact, right? So someone has moved that money and they said that we weren't, you know, there's no way I could delay that because there's no statute that says there's nothing that covers me liably, and this person moved a lot of money. We've never had someone come in and say, well, because they wanted to move rent money or something like that. It's another investment that just doesn't sound right, that raises in the industry red flags to that investment advisor representative are the ones that we typically deal with, where people are moving money. And honestly, some of those, we could tell them within a couple of days that the person you're sending that to is already looked into by another state or those types of things. But we just haven't had, we get some of these cases, and we just believe that this would be a good remedy for that. I wanted to talk to you about the days. So they have to notify within 2 days their investor that they're going to do something with this their account, either delay it or to go ahead and notify us. They have to notify us within 7 days. And they cannot, the investment advisor representative cannot hold the money or delay the fund transfer for 25 days. Only we can do that in our office. They can delay it for up to 15.
Thank you for some of that clarification. It doesn't really, you know, just doesn't sound right. Just believe is kind of gives me pause and some concern. It's a lot of authority we would be giving to broker-dealers or investment advisors over other people's finances. So just want to make sure that we're carefully looking at it and appreciate the testimony and the answers as well, and as we look at this bill. Thank you, Mr. Chair.
Any other additional questions on Senate Bill 62? I see none. We will close the hearing on Senate Bill 62, as we have no other proponent, opponent, or neutral testimony received at this time. Committee, that completes our work for today, and we will be back at it tomorrow. We're adjourned.